You were hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 40 years.
When you look at everything this woman has done and every one of these offenses, she has lied to every moment. She has done everything. The only thing she's telling the truth about in this court today is going to be that she actually shot him and killed him. That's it.
And this shows she pleaded guilty on February 23rd. I don't have February 23rd, 2026 here on my screen to refer to.
Just you may have already processed the plea papers.
Also a little confusing, Judge, because she had two different sets of cases that are unrelated to each other with two different lawyers. So that may be creating some chaos as well.
Okay.
But
There is another case. So we have two murder cases here
yes, Judge.
on different dates.
Yes, Judge. And we're
Okay. I didn't have on 41222. I've got nothing here.
that's what the 1245 is for.
1245 goes to that, Judge. She's admitting to committing that one, but she pled to the other one.
Is this you?
Yep. Yes, Judge.
Okay, I didn't. I can't come to. Thank you.
If I had a cool name like John B. Stevens, I would write it all out. But
But you said there was another lawyer involved.
there's
There was a sexual assault as a child that she also pled to. It's already
We
been
don't need
sentenced.
any other lawyers to be here
No,
this year.
yes.
She's already been sentenced on that one.
You're handling both of these
That's correct, Judge.
independently
Correct.
indicted murder cases
Yes,
on this lady.
Correct.
What is our master plan?
We're asking you to follow the agreement.
Which is a cap of 40 years.
Correct. There's a
Well,
fun stuff in the pre-sentence report, but it's okay. I think she covered it in the second memorandum that we were having trouble with her accepting responsibility, but she did, I think, in the second memorandum. Kind of.
in each of this states though that 41222 will be dismissed.
Yes, but you're considering the 1245 allows you to consider the punishment for it.
Okay.
But
I just
yes, sir.
wanted to make sure.
Yes,
that
sir.
There's not going to be, there will be dispositions, but one guilty disposition, one dismissal disposition.
Correct.
We call two cases, 22-40354 and 22-41222, the state of Texas versus Lace Christian. That is you?
Yes, sir. Yes, sir.
Present with Mr. Gertz, your attorney, and the state's attorney. Earlier, you pleaded guilty in cause number 22-40354 to the first degree felony of murder, which alleges that you shot the complainant with a deadly weapon, namely a firearm, killing the defendant, the complainant, and that this is a first degree felony. And a pre-sentence report had been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it, state of Texas
Not from the state, yes.
and defense?
No, Judge.
Then it's made a part of this hearing for all purposes. Now, the agreement is whatever sentence shall not exceed a cap of 40 years imprisonment. So we are looking at no less than 5 nor more than 40 years confinement in prison.
Yes, Judge.
And is deferred or unadjudicated probation even on the an option?
No, because of the nature of the offense, Judge.
And regular probation is certainly not as well.
Correct.
So it is a flat time issue.
Yes, Judge.
And one other case 22-41222, that will be dismissed as part of this agreement, but the court can consider the facts under that case in making its decision of the sentencing in this cause number 40354, and 41222 is an indictment handed up for the first degree felony of murder. Okay. State of Texas may open and close. Go ahead.
Judge, of course, we're asking for the 40 years. There's two homicides that she has admitted to. One that she pled guilty to, one she's admitted to in the 1245 that she also committed that one. So with two murders, it's easy to say 40 years is kind of light, but due to the circumstances of everything we looked at and talked about and the fact that she's kind of accepting responsibility. I'm going to get into that. The problem I have with this whole thing is when she first did the pre-sentence report, she tried to go away from not taking responsibility. She didn't want to take responsibility for this homicide. Then she cleared it up. And when she clears it up, then she comes back and tries to blame it on her friend who has never met this man. She says that this man, Russell Rito, pulled his penis out and tried to get her to do things. And so they ended up shooting him and killing him. But when this man was found, he was sitting in a easy chair with his hands folded, fully clothed, not looking like he had even moved, and was shot while he was actually sleeping on the easy chair. And unless she took the time to try to dress him back up and do all the things to cover up what had happened, which doesn't make sense if that's the reason why she's saying she killed him. She also lied to the police whenever the police started talking to her about whether she'd gone back over there again. We have surveillance video and also her GPS showing she went back over to the house again with her friend to go take a cell phone back and to check on things. The next day, she says she went and tried to check on her grandfather, acting like she didn't do anything, knocking on the door. She said she knocked on the door to see if he was there and he wasn't there, or didn't answer, so she went to the neighbors. But when you watch the videos, she gets out of her car and never goes to the door to knock because she knows he's dead. She goes and talks to the neighbors, acting like she never knew anything had happened. When you look at everything this woman has done and every one of these offenses, she has lied to every moment. She has done everything. The only thing she's telling the truth about in this court today is going to be that she actually shot him and killed him. That's it. And I don't care about the motive. I don't care about anything else. She's admitting to doing it. And so we're asking for the 40 years. And she also admitted on Lonnie Scott, who was an Uber driver, that she had a one-time sexual encounter with. And then she's admitted to actually killing him also. So we'd ask for the 40 years. I don't think there's anything less you can give her.
Judge, we want the court to just follow the agreement at this point. Candidly, Judge, my client has struggled. She's had a lot of difficulty in her life and has trouble trusting people. And I think that has yielded a number of times in dealing with the police and the probation department where she has not been forthcoming in a way that she has been with me. But what I can tell the court is she has now in the sexual assault cases and now in these cases is here accepting responsibility, and we want the court to follow the agreement, please.
All right. Did you want to say anything, ma'am? No. Okay. So I want to just be clear on a criminal history. We've got this previous aggravated sexual assault of a child conviction, correct?
Yes, Judge.
And this was a sentence that occurred just recently?
Correct, Your Honor.
Where she received 12 years imprisonment, and this was an offense that had dated back to 2014, correct?
Yes,
that's correct, Judge.
The court has reviewed the pre-sentence report and a recent memorandum supplementing this report. submitted by the Jefferson County Probation Office that was performed at the request of the defense, which asked for a supplemental due to statements that she had made during the interview. And then there is what happened the day of the offense. And I'm going to ask from probation, is probation officer here? That it was.
The author's not here, Your Honor.
Okay. All right. Y'all read it.
Yeah.
And there was some concern about the defendant pleading guilty, and then in her explanations of her version of the events, seemingly not admitting responsibility for this.
Yes, Judge.
So that was from the original pre-sentence report. So we supplemented this with a follow-up.
Yes, Judge.
And then in this report, the way I read this, I'm still confused. It seems like she continues not to accept responsibility. That someone else is the one responsible. Can that be explained for the record? Because she's pleaded guilty under oath.
She has.
And I think we made it clear and methodical, but it's as though she's pleading guilty but I'm really not as guilty as you might think.
But as the court knows, when you have these types of offenses, one of the things is that people get charged even as parties, and they don't have to be specifically said as a party or anything else. I'm not saying that's what's happening here, but I am saying that had we gone to trial, she is well aware that she was present, she participated actively, and I think she's having candidly sort of a mental block about really saying I'm the one that pulled the trigger. But the reality is, Judge, that she is accepting responsibility through her plea and in recognition that she would be convicted as a party at worst, even if those events are somehow how she described. So
is all of that true, what he's saying?
Yes.
Yeah. You understand? What I understand Mr. Gertz is stating, and in the legal way he does things, which is a good way and an appropriate way. You have pleaded, the fact of the matter, you have pleaded guilty. And I ask you, when you pleaded guilty under oath to murder, are you pleading guilty voluntarily and because you are guilty? You said yes. And do you understand that someone can be guilty of murder by willingly participating in the act of the murder?
Yes, Your Honor.
And you admit that you at least did that.
Yes, Your Honor.
And you did that voluntarily, knowingly,
Yes.
and accept responsibility for being part, if not completely responsible, at least being part of the responsibility as a party to the offense, as the law states, parties to an offense are culpable or can be held responsible under law.
Yes, Your Honor.
All right. Anything else to add by anyone?
And Judge, part of that,
Yeah.
it's just there's shame and embarrassment and things like that when you do something that you shouldn't have done and you know you shouldn't have done. And so I think that's just one of the challenges that people have as a natural human reaction here. But again, we're asking the court to just follow the agreement and accept her acceptance in the form that it comes, and asking the court to follow the agreement.
Anything else? Tell anybody? If nothing further, then Lace Christian, I'm going to find you have pleaded guilty to this first-degree felony of murder voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1, admitted at your plea hearing to find you guilty beyond a reasonable doubt. And your culpability has been supported as well by the findings from this hearing that you admit to being a party to this offense voluntarily, knowingly, intelligently, and being responsible as a party to this offense, which resulted in the murder, homicide of a human being. You took an active role in that to make that occur. Correct.
Yes, Your Honor.
I now find you guilty beyond a reasonable doubt of this first-degree felony of murder. I am following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice